The blue lights appear in your rearview mirror like a sudden, unwelcome dawn. Your heart rate spikes. Your hands grip the steering wheel a little tighter. You're already running through the mental checklist. Was I speeding? Did I miss a turn signal? Is my registration up to date? But as the officer approaches your window, the question that comes out of their mouth isn't about your driving at all. I smell alcohol. Have you been drinking tonight? And just like that, a routine traffic stop has transformed into something else entirely. Here's the question I want you to think about, and I genuinely want you to take a moment to consider it, and drop your answer in the comments below. Have you ever been asked that question during a traffic stop, and how did you respond in that exact moment? What did you say or do when the officer made that statement? I'm asking because your answer matters more than you might realize, and by the end of this article, you'll understand exactly why I'm asking. So go ahead and share your experience in the comments, because what I'm about to explain might just change how you handle that situation forever. Let's be absolutely clear about one thing right from the start. When a police officer says, "I smell alcohol," they are not making a scientific observation. They are making a tactical move. This statement is one of the most powerful tools in a police officer's roadside arsenal, and understanding why they say it and how you should respond could mean the difference between driving home and facing a DUI charge. Let's think about what happens in those first few seconds of a traffic stop. The officer has already made a decision to pull you over. That decision is usually based on something they observed, maybe a minor traffic violation, maybe something more subjective like weaving within a lane. Now, as they approach your window, they are gathering information. They're looking at your eyes, listening to your speech, and using every sense to build what they call probable cause. And the easiest way to build that case? It's the smell of alcohol. Here's what many drivers don't realize. The odor of alcohol is treated by law enforcement as a primary indicator of impairment. It's almost a reflex for officers to mention it in their police reports. One lawyer who defends DUI cases regularly points out that nearly every DWI police report will start with a mention of this odor, usually as soon as the officer gets within 5 feet of an alleged drunk driver. And they don't just say they smell it, they'll describe it as moderate, strong, or even overwhelming. It sounds damning, doesn't it? It sounds like they have you dead to rights. But here's where my opinion starts to get a little more skeptical, and I want you to pay close attention here. Scientific evidence simply does not back up the officer's claim that a strong smell equals strong intoxication. There are studies that have directly tested this. In one study published in a peer-reviewed journal and supported by the Insurance Institute for Highway Safety, researchers found that odor strength estimates were unrelated to BAC levels. They concluded that an officer's estimate of a person's blood alcohol content based on smell was essentially just a random guess. Think about that for a second. The officer's confident statement about your level of intoxication is about as reliable as rolling dice. So why is this so important? Because the entire trajectory of a DUI stop often hinges on that one single statement. The moment the officer says they smell alcohol, they have what they believe is a legal justification to extend the traffic stop. They don't need much else. In legal terms, they can use that odor to justify a further investigation. This could mean asking you to step out of the car, performing field sobriety tests, or eventually making an arrest. As another legal source puts it, alcohol odor is a characteristic of nearly all DUI police reports, providing enough cause to detain an individual for further DUI investigations. Let's break down exactly what happens next, because this is where most people make a critical mistake. The officer says, "I smell alcohol." Instinctively, many drivers feel the need to explain themselves. They get nervous. They feel like they have to prove their innocence. So they say something like, "Oh, I had one drink 3 hours ago," or "My friend spilled a beer in the car last week," or they try to make a joke about it. Stop right there. That is the moment you are giving them the evidence they need. You are confirming their suspicion. By admitting to any alcohol consumption, even if it was a single sip, you are handing them a piece of the puzzle they need to build their case against you. A defense attorney warns that your response to police questioning can significantly impact your case outcome. Every statement you make becomes potential evidence in court proceedings. So when you say, "I had one beer," you're not explaining yourself. You're providing them with a confession of consumption. So what are you supposed to do? You need to say this: "Officer, I understand you have a job to do, but I am going to respectfully decline to answer that question, and I would like to speak with my attorney." I know, it sounds dramatic. It sounds like something from a movie, but in reality, it is the most effective, legal, and respectful way to handle that question. Let me explain why. First, you are asserting your Fifth Amendment right against self-incrimination. This is a constitutionally protected right. Police officers are trained to ask questions and interpret silence or admissions as guilt, but this is a situation where silence is quite literally your best defense. You are not obligated to help them build a case against you. I've seen attorneys repeatedly advise, avoid admitting to any alcohol consumption. Request to speak with legal counsel before answering questions. It's that simple, and yet so few people actually do it. Second, by declining to answer, you force the officer to rely on their objective observations rather than your subjective admissions. If they are going to arrest you, they have to do it based on actual evidence, not based on a nervous confession you gave on the side of the road. This gives you a much stronger position to fight the case later. Now, let's address the elephant in the room. The fear that if I refuse to answer, I look guilty. I hear that all the time. But I want you to question this assumption. Police officers are suspicious of everyone they pull over. It's part of their job. You cannot talk them out of being suspicious. In fact, the more you talk, the more opportunities you give them to find something suspicious. If you fumble over your words, they'll write it down as slurred speech. If your eyes are tired, they'll describe them as glassy. If you're nervous and your hands shake while you hand over your license, they'll call it a sign of impairment. You are not going to win this argument on the side of the road. This is where the psychology of a traffic stop becomes really fascinating. Officers are looking for indicia of intoxication, but as some legal experts have pointed out, many of these are actually just indicia of consumption. There's a big difference. You can have 2 glasses of wine with dinner, be completely sober, and still smell like alcohol. That smell doesn't mean you're impaired, but it gives the officer the legal basis to detain you and investigate further. Let me illustrate this with a couple of scenarios that happen every single day. Scenario A, the honest driver. You get pulled over. The officer says, "I smell alcohol. Have you been drinking?" You think you're being smart and honest. You say, "I just had 2 beers a couple of hours ago." The officer asks you to step out of the vehicle. Because you've admitted to drinking, they have reasonable suspicion to perform field sobriety tests. Now, field sobriety tests are a whole separate can of worms. They are notoriously subjective and flawed. Scientific studies have shown their accuracy rates to be far from perfect. If you fail one, you are arrested. Now you have to fight a DUI charge that started with your own admission. The prosecution now has your statement, which can be incredibly hard to challenge in court. Scenario B, the intelligent driver. You get pulled over. The officer says, "I smell alcohol. Have you been drinking?" You reply, "Officer, I understand you need to do your job. I'm not going to answer that, and I would like to speak to a lawyer." The officer may be annoyed. They may ask again. They might even threaten you, saying if you have nothing to hide, you should just answer. But by sticking to your script, you are refusing to give them evidence. They now have to decide whether they have enough to arrest you without your confession. They might still arrest you based on the smell and other observations, but now the legal burden is on them to prove you were impaired. And just as importantly, the arrest is based on their observations, not your words. When a lawyer challenges this, they have a much stronger case because they can point out that simply smelling alcohol cannot provide any information about a person's actual blood alcohol level. Now, a lot of people worry about the officer holding their documents too long or asking them to step out of the car. This is all part of the investigative process. In many jurisdictions, the law allows an officer to detain you for a reasonable amount of time to conduct their investigation. They can check your license, registration, and insurance. During this time, they are also looking at you and speaking with you. If they smell alcohol during this initial legal detention, it can justify extending the stop. For example, a Wisconsin court recently ruled that an odor of intoxicants and the driver's prior conviction for OWI established reasonable suspicion to extend the stop. So if you have a prior record, even a minor one, the stakes are even higher. This leads me to another critical warning. Do not fall for the small talk trap. The officer may start asking you where you're coming from, where you're going, or what you did that night. They are not just being friendly, they are gathering evidence. When you answer, you are making a statement about your actions and timeline. If you say you were at a bar or a party, that's another piece of information they can use. I cannot stress this enough. Keep your answers brief, polite, and limited to the legal necessities of the stop, like your name and address. And what about those little mistakes that turn into big problems? Let's talk about chewing gum, for instance. It might seem like a harmless habit, but Kyla Lee, a DUI attorney in Vancouver, points out that officers are trained to believe that people who chew gum are trying to mask the odor of alcohol on their breath. The same goes for wearing strong cologne, smoking, or vaping. These innocent actions can trigger an officer's suspicion. So if you are a smoker, or you just put in a piece of gum, be aware that the officer might interpret that as an attempt to hide something. Let's dig into what I said earlier about the officer holding your documents. This is another common mistake. If you are in a situation where you've handed over your license and registration and the officer is taking a long time, you might feel trapped. But remember, they are allowed to run checks. They are allowed to call for backup if they suspect you of a crime. You are not free to leave while they do this. If you do try to leave, you will likely be arrested. This is why it's so important to remain calm and not escalate the situation. When you step out of the vehicle, be careful. The officer is watching how you move. They are observing whether you use the car for balance, how you walk, and your general coordination. Even if you are perfectly sober, nervousness can make you stumble. And remember, the officer will note any perceived unsteadiness in their report. The case law is full of examples where officers claim someone was swaying or stumbling. If you have a medical condition that affects your balance, you may want to mention that. But again, you need to be careful about what you say. Passengers also need to be aware. An officer can legally question a passenger in a stopped vehicle. If you are a passenger and the officer asks you questions, you have the same rights as the driver. Do not volunteer information. Do not admit to drinking. You are not under arrest, but anything you say can be used against the driver or yourself. There is case law from Minnesota that explores this exact situation, where police attempted to question a passenger about an alleged condition of release. The key takeaway here is that everyone in the vehicle has rights. Now, let me address one of the most dangerous myths that I see circulating online and in driver forums. The idea that you can refuse a breath test without consequences. This is a very dangerous misconception. In many states, refusing a chemical test like a breathalyzer or blood test comes with immediate and severe penalties. In Texas, for example, the administrative license revocation hearing runs in parallel with a strict 15-day deadline. If you refuse, your license can be suspended automatically, regardless of whether you were actually guilty of DUI. You need to understand the laws in your specific state. There is also the misguided belief that if you just blow into the device and you're under 0.08, you'll be fine. But you also need to think about what happens if you're over the limit. A breath test result is a very difficult piece of evidence to fight. So the question of whether to take the test is highly complex and depends on the specific facts of your case. But I will say this, the decision to take or refuse a breath test should be made in consultation with an attorney, not on the side of the road under pressure. Let's talk about the emotional pressure of the moment. It's real. You're scared and your heart is pounding. The officer is trained to maintain a calm, authoritative demeanor, and that can be very intimidating. There is a moment of silence after you say you won't answer their question. It feels like time stands still. The officer might stare at you, waiting for you to crack. This is a psychological tactic. You need to be prepared for this. You need to practice saying your line in your head, so when the moment comes, you can say it calmly and confidently. The reality is that an odor-based arrest raises serious legal concerns, including whether probable cause existed to make the stop and whether the arrest violated your constitutional rights. In many cases, an arrest that is based primarily on the odor of alcohol and questionable field sobriety tests can be challenged and even dismissed. I have seen cases where the entire case was thrown out because the only evidence was the odor of alcohol and the officer had no other objective signs of impairment. So, what do you do if you are arrested? The fight is not over. It has just begun. This is where you need to get a lawyer involved immediately. A good DUI defense attorney will review the entire traffic stop. They will look at the dash cam footage, the officer's report, and the circumstances of the stop. They can challenge whether the officer actually had the right to pull you over in the first place. They can challenge the reliability of the field sobriety tests. They can challenge the odor of alcohol as nothing more than a subjective, unscientific observation. A skilled attorney knows that the mere odor of alcohol about a driver's person may be indicia of alcohol ingestion, but is no more a probable indication of intoxication than eating a meal is of gluttony. The courts have sent mixed messages on this issue, but there is a growing awareness of how unreliable the smell test really is. While some courts have held that the odor of alcohol, combined with other signs, is enough for probable cause, there is a strong legal argument that the smell alone, especially a slight or moderate smell, is not sufficient to establish intoxication. One study I mentioned earlier essentially concluded that an officer's estimate of a person's blood alcohol level based on smell failed to rise above random guesses. If you end up in court, this is exactly the type of scientific evidence your lawyer should be using to dismantle the prosecution's case. Now, let's think about the bigger picture. We all need to be more aware of our rights on the road. We are not powerless. The police have a lot of authority, but we also have rights. The key is knowing how to exercise those rights respectfully and effectively. It's not about being combative. It's about being intelligent. It's about protecting yourself from making a split-second decision that could have long-term consequences. A DUI conviction can affect your employment, your family, and your finances for years to come. As one legal expert advised, it is important to remain polite and respectful throughout the interaction, and to not volunteer additional information beyond required documents. Cooperating with lawful orders, like providing your license and registration, is required. But answering questions about where you were going, what you were drinking, or how much you had to drink is not. And if you feel your rights are being violated, do not argue with the officer on the scene. The side of the road is the wrong place to make a legal argument. Argue later in court with a lawyer. As one attorney aptly put it, cooperate now and complain later. That is the golden rule of traffic stops. Before I wrap this up, I want to come back to that question I asked you at the beginning. I asked if you've ever been asked that question and how you handled it. The reason I asked is that so many people share stories with me about how they felt helpless or didn't know what to do. They often tell me they wish they had just kept their mouth shut. If you have a story, good or bad, drop it in the comments. Your experience could help someone else who finds themselves in that same situation tomorrow. Now, let me give you a little preview of something important that I'll be explaining in more detail in a future article. We haven't even touched on the dirty tricks some officers use during field sobriety tests, or how the specific language you use can completely change the legal outcome of your case. There is so much more to this. But for now, I want you to leave with this clear understanding. When an officer says, "I smell alcohol," they are starting an investigation. They are trying to build a case. Your response to that statement will determine how far that investigation goes. Do not give them a voluntary confession. Do not try to explain away the smell. Be polite, be respectful, and state that you are declining to answer the question and would like to speak with an attorney. The officer might be suspicious of you anyway. That's okay. Suspicion is not guilt. They need evidence to convict you. By refusing to provide them with that evidence through admissions, you are giving yourself and your future lawyer the best possible chance of fighting the charges. I have seen too many good people get caught up in the legal system because they were nervous and said the wrong thing. They didn't know their rights, or they felt pressured to cooperate beyond the legal requirement. This is your life, your license, and your record. You have to protect it. So remember, the next time those blue lights flash behind you and the officer makes that statement, you're not being rude by staying silent. You are being smart. You are exercising a right that was designed to protect you in exactly this kind of situation. Drive safe, be smart, and always know your rights.